You got to watch that play out in court to say that there will be no defense, there will be no witnesses called on behalf of the defense. Just taking a listen into court briefly to see if we can hear any instructions, but there is this idea of confusion. In fact, while we wait, I want to play some sound from yesterday afternoon, some testimony from yesterday afternoon. This is the lead detective for the city, or for the Akron Police Department on this case, Detective Michael Williams. He was on the stand. It was the conversation about why would two of Ethan's friends say it was Donovan that came over to confront, and one said it was Deshaun. So take a listen to the defense. I'm going to continue to monitor the courtroom. You won't miss anything. When the jury comes in, the defense will rest, and then more than likely they will proceed right to closing arguments. Closing arguments could be 20, 30 minutes on each side. Then there will be jury instructions. We'll have to see if, as we get closer to noon, will they break for lunch and then do the jury instructions and then give the case to the jury? So again, I think by mid-afternoon, this case will go to the jury, and depending on how much discussion there will need to be, we'll have to be on jury watch. We have seen there aren't a lot of charges. Sometimes in past cases where someone is charged with murder, aggravated murder. That's not the case here, but I'm just speaking in generalities here. When you have somebody that's charged with murder, aggravated murder, negligent homicide, involuntary homicide, assault, simple assault, felony assault, the jury then has to go through each one of those charges and talk about that charge and why it does or does not meet the definition and what was proven in court. So sometimes when there is a long list of charges, you know it's going to take that jury some time, simply almost from a paperwork standpoint. But in this case, there are not all that many charges. Deshaun is facing 2 counts of involuntary manslaughter. I believe one of them is a felony 1, an F1, that then ties into the aggravated assault. His brother Tyler is just facing 1 involuntary manslaughter charge and 1, I'm going to make sure I get this right here in my notes. His brother Tyler, 1 involuntary manslaughter and 1 assault. Because obviously to have involuntary manslaughter, there had to have been an assault that occurred. So they'll have to start at that assault. Was there an assault that occurred? Was that assault what led to the involuntary manslaughter? So with there not being a lot of charges, it may not be one of those 2, 3, 4 days that the jury has to deliberate. I would be shocked if this went multiple days in getting a decision from the jury. Do they think there's enough confusion to throw the whole thing out and come back with a not guilty? Or do they think that when Deshaun was sitting in that interrogation room saying, I punched him and he went right to sleep, is that the piece of evidence they need? It'll be interesting. But let's get back to this idea of confusion. You're going to hear from Detective Williams on the stand yesterday afternoon talk about how can it be that there are conflicting ideas of who confronted Ethan in the first place. Take a listen.
And who did you conclude was the first person to approach the boys at the key?
Through interviewing through interviewing.
And I actually want to stop right there. Did you see that? Did you see the detective through interviewing Don? He went to say Donovan. So yes, the names are similar, Donovan, Deshaun, but even and that's why the detective sort of did that grimace or that laugh, because even he is starting to get confused by the names and the identities, and perhaps will that play in the favor of these 2 young men. Let's watch it again.
And who did you conclude was the first person to approach the boys at the key?
Through interviewing through interviewing Deshaun Stafford, he stated that he was the first one to go up to the car.
And did that explanation match up with descriptions in video evidence that you had.
Yes, with the height of all four of the individuals that had came out of the basketball court. Donovan Jones is noted as the tallest one of the four people, and he was not the first person out of the basketball court to approach the car.
Okay, do you know what number person he would have been to approach the car?
It's either second or third, I can't remember.
But today and yesterday, two of the three state's witnesses give testimony inconsistent with Sean's statement. Two of the three say Donovan was the one that walked up to the car, and Donovan was the one that got shot in the face. Right?
That is what they said.
Now, Donovan didn't get charged with Ethan's death. He's out of this thing, right?
I don't know the legal term for charged, and I don't know if I'm allowed to talk about what I did in the course of my investigation as far as who I charged.
Donovan's no longer facing charges. It's over for him, right?
That's correct.
And he certainly never was held responsible for anything to do with Ethan's death.
Correct.
And those are based on statements that you were given that night and the investigation you did at that time. It kind of made sense, but would you agree with me that now it seems like Donovan's a whole lot more involved if we take the state's witnesses at their word?
As far as Ethan's death,
Yeah, as far as Donovan's involvement, it seems to have changed from what we initially thought to what the witnesses are saying now.
I can agree that there is definitely some kind of identity communication problem here.
People seem to be switching to Sean and Donovan to Sean, and they seem to have switched them up. And I'll withdraw that. Is there anybody other than Deshaun saying that Deshaun's the one that punched out Ethan?
Through the course of our investigation, we interviewed 6 people, and that's how we got all of our information. The description of Deshaun was his braids and the coloring of his braids, and that's how we came to our conclusion.
But that's coming from those kids who are now kind of changing what they originally told you.
It's coming from the 3 kids as well as Deshaun himself.
Okay. So the 3 kids originally told you one thing and now they told you something different. But would you agree with me that none of those 3 kids can say that Deshaun threw the punch?
They did tell us that night.
Okay. But they didn't say here in court.
In court, it appears they were confused about something, yes.
Again, there appears that there was some confusion about something. Yes, that's because 3 of Ethan's friends testified. 2 of them said they think it was Donovan, the bigger of the 3, that came out and started the confrontation, because remember, that confrontation leads to the first 1-on-1, then it's 2-on-1, then it's 3-on-1. And we heard the prosecution there when the judge was talking about throwing the case out, just showing you the courtroom. We're not missing anything here. When the defense tried to get the whole case thrown out, you heard the prosecutor get up there and say, to call this a fight is insulting. It was an attack. Throwing out this idea of this was not self-defense, this was 3-on-1. I'm reading an exact quote from the prosecution as they tried to get this case thrown out. They said this was not self-defense, this was 3-on-1. To call it a fight is insulting, this was an attack. The judge agreed that this should be sent to the jury and ultimately let the jury decide. We're sort of in this holding pattern, listening in here, not a lot going on in court. We will need to get the jury back into the courtroom. It'll be said on the record in front of the jury that the defense rests their case without calling any witnesses, and then they will have to start with closing arguments. I really don't think closing arguments will last all that long, but you do have to hear from 3 individuals. You have the state, then you'll have Deshaun's attorney, and then you'll have Tyler's attorney. there was some interesting conversation the defense had with the detectives on the topic of cell phones. It's been very interesting to watch this case play out and all of the conversation about cell phones. Originally, in the defense's opening argument, they said this was a TikTok prank. They were filming it. They were going to put it on TikTok when they rolled up and shot him with the splatterball guns, and it was a TikTok prank gone wrong. Well, all three of Ethan's friends got up on the stand and they were asked, "You were doing this for TikTok, right?" And all three of them said, "No, nobody was recording this at all. This had nothing to do with TikTok. We were just being dumb kids and pulling this prank." So that fell apart for the defense a little bit. But then, when we go back to the conversation of cell phones, we see Tyler, when he moves Ethan's car, he goes through the car and he's able to find at least 2, if not 3 of the cell phones that were in the car. The young men, in the midst of the fight, in the midst of the chaos, left their phones in Ethan's car. We see Tyler, as soon as he gets out of Ethan's car, you see this flash come across the surveillance video, and that is supposedly Ephraim. Ephraim's who called 911 from inside the car, that was Ephraim's phone that was smashed right there on the concrete. There were also phones that were smashed down by what we call round 2. When they pulled the car up to try and get Ethan's body, there were cell phones that were smashed there. The one cell phone that was never found was Ethan's. And we know Ethan had a phone because when they were in the car and they were about to go do this, the prank at the I Promise school, we've heard his friends testify that Ethan got another text message to go sell weed to another set of customers or another couple of individuals. And so they were going to ride along as Ethan went to that next house. But it was on the way to that next house that they saw the 3 individuals on the basketball court, and we know what happened then. So we know that Ethan had a cell phone at one point, but his was never recovered. And you get this conversation about how important are cell phones. And again, put yourself in the jury's position. You have Deshaun and Tyler and Donovan on the run for 9 days after this incident. How much conversation would they have had back and forth about, did you hear that kid died, blah, 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 what are you going to say? Don't say anything. You know, whatever kids are going to say back and forth. The prosecution, or at least the detectives, never went through the phones of the suspects. At that point, Donovan was a suspect. Remember, he pleaded no contest, and his part in this case is over, pleaded no contest to 2 assault charges, and his part of the case is over. But they never once, according to the detectives, went through the phones of Tyler and Deshaun. Could there have been some good evidence in that phone in the minutes after, in the 9 days after? And so the fact that the detectives never went through their phones, they never really went and looked for the phone of Ethan Liming. To this day, still missing. Did somebody take it? Did they throw it in the woods? Did they try and smash that one? We don't know. And that is brought up to the detective yesterday, the lead detective on this case for the city of Akron. And again, this is all to put doubt in the mind of the jury. Are they guilty beyond a reasonable doubt? Take a look and listen to this testimony yesterday about what happened and the conversation around cell phones.
So knowing that things change and people change, there are things we could have done to try and see what, we have scientific things we could have done, right?
Yes.
Like you had the phones from all the boys in the car, and that could have told us what happened leading up to this incident, right?
It's possible.
But according to Detective Mike Williams, he didn't see a need for it, you didn't see a need for it. Which would have been simple as turning them on and seeing if you could read the last day text messages, right?
No, it would not be as simple to do that, no.
We all have cell phones. We've all lost data. You have a whole crime lab up there on the second floor and they've got a machine that deals with phones, right?
That's correct.
In this case, we don't even bother to turn these things on to see if you can read them through the glass, the broken glass.
We did attempt to turn them on, but they were broken and they would not turn on.
And there's a next step you could have followed that we just chose not to. We didn't send it out to get looked at. We didn't send it to the crime lab. We just turned it back off.
We sent it to the crime lab for DNA processing.
Well, let's talk about DNA. Well, let's stick on phones for a minute. Ethan's phone's missing, right?
Yes.
That seems odd.
Yes.
It's an iPhone, right?
That I don't know.
Okay. Well, iPhone, Android. When you contact the phone company or talk to the parents and said, find my iPhone, find my Android. Where did it pop up at?
I did not do that. I believe Detective Mike Williams might have.
We didn't hear about that, right? I mean, that's a mystery where the phone went.
Yes.
We don't even know whether or not someone's still using that phone today. I mean, the phone company would have records, but somebody would have to go get them. And no one did that, right?
No.
And likewise, maybe even more importantly, these boys on the basketball court had 9 days to talk back and forth to each other. We could assume. They're all relatives, right?
Yes.
They all are reading the paper and watching the press conferences, and you can assume, you can guess they're probably talking about getting their story straight.
It's possible. I don't know.
You took each one of their cell phones into custody when you arrested them, did you not?
I don't recall. I'm not sure.
That would be pretty easy to do. You arrest them, you take them, you ask for their cell phone, and then you turn the cell phone on, you look back and you go, that's where you guys got your, that's where you did that. But we didn't even turn on the suspects' phones to see what kind of things they were saying before the incident, after the incident. That'd be good to know, wouldn't it? Especially now with Donovan's different involvement.
Yeah. Through the course of our investigation, through our 6 interviews, I did not see the need to have the phones due to the cooperation of everyone.
I guess what I'm saying is we don't know these people, these kids, these other people.
And I'm going to jump out of this as we see the judge is back in the courtroom. I believe we'll get the all rise for the jury. Now it looks like I can admit I'm a little confused here as to where they're headed. It looked like they were headed back for another conference. So we will wait and see. Again, Deshaun and Tyler Stafford facing very serious charges here. And the wheels of justice are turning here. Going to turn a little quicker than anticipated today based on the fact that it does not appear the defense will be calling any witnesses. But from that testimony, and in fact there's the detective sitting right there, the lead detective on the case, just very interesting that at no point did they, you could have gotten a subpoena for the phone from the young men. You could have worked with the cell phone companies, especially the ones that were had the screens broken. You heard the detective say we tried to turn them on and they would not turn on. That doesn't mean they're useless. We all know that data can be recovered even from broken phones. They have technology, and that's what the defense was trying to say. You have a whole second floor up there in Akron that can work on issues like this. We've seen cases in the past where even though someone tried to destroy a phone, they were still able to pull information off of it. Maybe not full text messages, but perhaps something, maybe voicemails that are left. And at no point did they think it necessary to get that information, to open up those cell phones. The detectives say it's because everybody was cooperating. They interviewed all 6 subjects. That means 3 witnesses and the 3 men who were on the basketball court. They were all willing to participate. None of them wanted an attorney. So that's why the detective said they didn't go after the cell phones. I find that odd personally, not even in regards to this case. I'm just saying in regards to the immense amount of court I've covered in my career, that cell phone ends up holding an immense amount of information, whether it's geodata locations, like where you were located, where you went, where did these young men go after the attack, where did everybody go, that would have shown that. But the detective didn't feel that necessary. It looked like they went back for another sidebar with the judge, so we will wait to see on that. But in the meantime, let's listen to more testimony. You're about to hear from Lamar Dancy. He is the one witness, the one friend of Ethan's who was in the car, who was able to not only identify in his testimony that he thinks it was Deshaun that was the aggressor. He's the only one of the three witnesses that the state said, can you point out where they are sitting, in the courtroom. So take a listen again to the testimony of Lamar Dancy. He would have testified, and maybe we won't get to it. In fact, we won't, as we see some of the attorneys, in fact, all of the attorneys heading back into the courtroom. We will wait on that and wait for the judge to come back in. The jury is obviously not seated. There was clearly one more issue that needed to be discussed by both the state and the defense. And so we will wait for the continuation of court. But again, what a fascinating trial to watch. It is unfortunate that this is where we are, but there have been so many twists and turns and surprises and confusion, and the defense apparently not going to call a single witness for either of the young men. We're not going to get any of that. No character witness, no expert witness, no testimony from parents. We know that Deshaun went home and at some point had a conversation because his mother knew where that splatterball gun was, Ethan's splatterball gun that Deshaun took from the scene. When he was interrogated, he said he took it because he wanted to have evidence that they were shot at by Ethan and his friends. So his mom knew something, and she was not called as a witness. Let's say Deshaun had, and we're doing a hypothetical here, but if you're asking why would you call Deshaun's mom, let's say Deshaun goes home and he says, Mom, I can't believe it. We were shot at by these guns. And then to defend myself, I went over there, first of all, to confront them, and he started shooting me more, and I tried to defend myself, and so that's when I punched him. So we don't get any of that. We don't get that story from his mom or explanation as to what her son did or didn't do that day. So we will wait, and it looks like here's the all rise for the judge. And we'll get the all rise for the jury. And this is going to be an interesting next few minutes, so let's take a listen in.
Please be seated. Okay, good morning, ladies and gentlemen. I do apologize for the delay getting started this morning. As I discussed yesterday, the lawyers and I had some things we did need to accomplish, and hopefully now things will go a little bit more fluidly for the rest of the day. When we concluded yesterday, the state had rested its case, and therefore I'm going to turn to the defense for any evidence that the defense may wish to present. Mr. Sin?
Your Honor, on behalf of defendant Sean Stafford, we are going to rest on the state of the evidence. Thank you.
Thank you, Mr. Sin. Mr. Gallick?
Your Honor, at this time, we have rested our case.
Okay. Would note for the record the renewal of the Rule 29 motions that we did discuss on the record previously. Okay, ladies and gentlemen, then I will tell you what the plan is here for the rest of the day. I am going to begin with some jury instructions for you. I'll give you part of them related to the charges, and then at that point we will break for lunch. I'm anticipating taking maybe a little shorter lunch than we have in the past. Then following lunch we will proceed with the closing arguments of counsel, and then I will have some further jury instructions for you related to how to conduct your deliberations. So I do have the jury instructions related to the charges that I will give to you now. I will tell you that you are free to take notes through the reading of the jury instructions. However, you should know that you will have copies of these, written copies of these with you during your deliberations, just so you don't feel like you have to write down every word that I'm saying. You can refer to them later. Okay. You have now heard all of the evidence of counsel, and it is my duty to instruct you as to the law that applies in this case. The court and the jury have separate functions. You decide the disputed questions of fact, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and to apply the law to the facts as you determine those facts to be. You are not permitted to change the law or to apply your own ideas as to what you think the law should be. A criminal case begins with the filing of an indictment accusing or charging the defendant with committing a particular crime. It is important that you understand that the filing of the indictment or the indictment itself is in no way to be considered by you as evidence against the defendant. The filing of the indictment informs the defendant that he has been accused of the offense. The plea of not guilty is a denial by the defendants of the crimes that are charged and puts at issue all of the essential elements of the crimes charged. The defendants are presumed to be innocent until their guilt is established beyond a reasonable doubt. The defendants must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the crimes alleged. I am now going to define reasonable doubt for you. Reasonable doubt is present when the jurors, after they have carefully considered and compared all of the evidence, cannot say they are firmly convinced of the truth of the charges. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. I will now define evidence for you. Evidence may be direct or it may be circumstantial or a combination of the two. Direct evidence is testimony given by a witness who has seen or heard or felt certain acts or facts to which he or she testifies. Direct evidence includes exhibits admitted during the trial and any stipulations by the parties. Evidence may also be used to prove a fact by an inference. This type of evidence is called circumstantial evidence. It is the proof of facts by direct evidence from which you may infer other reasonably related facts or conclusions which naturally and logically follow according to the common experience of mankind. Whether an inference is made rests entirely with you. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of the charged offenses beyond a reasonable doubt. The evidence, as I have said, does not include the indictment. It does not include the answers to questions you were instructed to disregard or the opening or closing statements of counsel. The opening statements and closing arguments of counsel are designed to assist you, but they are not evidence. You must not speculate as to the reason why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. The different varieties of evidence you have heard throughout trial are as follows. The first type and the majority of the evidence you heard in this trial is what we call testimonial evidence. That was where a witness took the witness stand, testified to facts they had knowledge of or had observed. You as jurors have the sole and exclusive duty to decide the credibility to give the witnesses. In determining that question, you will apply the tests of truthfulness that you apply throughout your daily lives. These tests include the appearance of each witness on the stand, their manner of testifying, the reasonableness of their testimony, the opportunity each witness had to see, hear, and know the things to which they testified, their accuracy of memory, their frankness or lack of it, the intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding that testimony. Apply these tests and you will assign to each witness the weight that you deem proper. You are not required to believe a witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should decide what testimony is worthy of belief and what testimony is not worthy of belief. Normally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. It is not necessary that a defendant take the witness stand in his own defense. The defendants have a constitutional right not to testify. The fact that the defendants, Deshaun Stafford and Tyler Stafford, did not testify must not be considered for any purpose. The second type of evidence admitted during the trial is real or demonstrative evidence. For example, this is a pen. If for some reason this was admitted in trial and had some relevance to the case, you'd be able to take it to the jury room, look at it and see what it is and see if it works and give it whatever weight you deem proper. Real evidence could be pictures, in other cases maybe drugs or a number of different things. It is any real object that was admitted during the trial. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as originally taken by the police officers, and you will determine what weight, if any, the exhibits should receive in light of all of the evidence. The third type of stipulation is what we call the third type of evidence is what we call a stipulation. Stipulations are nothing more than facts that both sides have agreed are true. I'm now going to go through the various counts of the indictment. In count 1, the defendant, Deshaun Stafford, is charged with involuntary manslaughter. Before you can find that the defendant, Deshaun Stafford, guilty, you must find beyond a reasonable doubt that on or about the second day of June 2022 and in Summit County, Ohio, the defendant, Deshaun Stafford, caused the death of Ethan David Liming as the proximate result of committing or attempting to commit aggravated assault. The state charges that the act of Deshaun Stafford caused the death of Ethan David Liming. Cause is an essential element of the offense of involuntary manslaughter. Cause is defined as an act that in the natural and continuous sequence directly produces the death and without which it would not have occurred. Defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's action or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the death was also caused by the intervening act of another person. If the defendant inflicted an injury not likely to produce death, and if the sole and only cause of death was fatal injury inflicted by another person, the defendant who inflicted the original injury is not responsible for the death. Before you can find that the defendant, Deshaun Stafford, was committing or attempting to commit the underlying offense of aggravated assault, you must find beyond a reasonable doubt that the defendant, Deshaun Stafford, knowingly caused serious physical harm to Ethan David Liming. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he was causing serious physical harm to Ethan David Liming. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. When an act is a crime, a good motive or purpose is not a defense. Cause is an essential element of the offense of aggravated assault. Cause in this context is an act which directly produces serious physical harm to persons and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's act or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the physical harm to persons was also caused by the intervening act of another person. Serious physical harm means any of the following: any physical harm that carries a substantial risk of death, or any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, or any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement, or any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Under Ohio law, a person is allowed to use force in self-defense or in defense of another. There are two standards for self-defense and two standards for defense of another. Self-defense may be by deadly force. Self-defense may be by non-deadly force. Defense of another may be by deadly force, and defense of another may be by non-deadly force. The standards that apply to each of those are distinguished based on the amount of force used and the level of danger presented. Deadly force means any force that carries a substantial risk that it will proximately result in the death of any person. Non-deadly force means any force that does not carry with it a substantial risk that it will proximately result in the death of a person. Substantial risk has already been defined previously for you, and you will see as I read these that there are numerous definitions that you can refer back to. I will tell you when I have already defined a term that is used again. To determine which standard of self-defense or defense of another to apply in this case, you must first determine the disputed questions of fact. Once you determine the disputed questions of fact, you must apply the appropriate self-defense or defense of another standard based upon your findings. I'll first talk about self-defense and the use of deadly force. A person is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that he was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of death or great bodily harm, or that the defendant used unreasonable force. Caused, deadly force, and substantial risk have already been defined for you. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use deadly force, or the defendant provoked Ethan Liming into using force, or the defendant did not withdraw from the situation, or the defendant withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk of life, or risk to life or safety, you may not consider the possibility of retreat by the defendant. Words alone do not justify the use of force. Resort to deadly force is not justified by abusive language, verbal threats, or other words, no matter how provocative. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. For you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant used more force than reasonably necessary and that the force used was greatly disproportionate to the apparent danger. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. A person is also allowed to use deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in defense of another. To prove that the defendant's use of deadly force was not in defense of another, the state must prove beyond a reasonable doubt at least one of the following. The person being defended was at fault in creating the situation giving rise to the injury, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of death or great bodily harm, or the defendant used unreasonable force. Again, caused, deadly force, and substantial risk have already been defined for you. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the situation resulting in the injury. The person defended was at fault if he was the initial aggressor and the person defended did not escalate the situation by being the first to use or attempt to use deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the person defended was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in defense of another, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the person defended. When considering deadly force in defense of another, you must apply the concepts of words and unreasonable force as I have previously set forth and defined. A person is also allowed to use non-deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in self-defense. To prove that the defendant's use of non-deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident. The defendant did not have reasonable grounds to believe that he was in immediate danger or danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of bodily harm, or that the defendant used unreasonable force. Again, the concepts and the terms caused non-deadly force and substantial risk have already been defined. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use non-deadly force, or provoked Ethan Liming into using force, or did not withdraw from the situation, or withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant has reasonable grounds to believe and an honest belief that he was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to receive bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. When considering self-defense by non-deadly force, you must also apply the concepts, their headed words, and unreasonable force, words as they are related to self-defense, as I have previously defined. A person is allowed to use non-deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in defense of another. To prove that the defendant's use of non-deadly force was not in defense of another, The state must prove beyond a reasonable doubt at least one of the following. The person defended was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of bodily harm, or the defendant used reasonable force. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the incident that resulted in the injury. The person defended was at fault if he was the initial aggressor, and the person defended did not escalate the situation by being the first to use or attempt to use non-deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that Ethan Liming was about to receive bodily harm. When considering self-defense by non-deadly force, you must also apply the concepts of words and unreasonable force as have been previously defined. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 1, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter, and you find that the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, guilty of count 1, involuntary manslaughter. Now I'm going to move on to count 2. In count 2, the defendant, Deshaun Stafford, is charged with aggravated assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant, Deshaun Stafford, knowingly caused serious physical harm to Ethan David Liming. Knowingly caused and serious physical harm have already been defined. When considering count 2, aggravated assault, you must determine whether the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or defense of another, and all of those terms have been previously defined related to self-defense. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of aggravated assault, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, not guilty of count 2, aggravated assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of aggravated assault, and you find that the state proved beyond a reasonable doubt that the defendant, Deshaun Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshaun Stafford, guilty of count 2, aggravated assault. In count 3, defendant Deshaun Stafford is charged with involuntary manslaughter. Before you can find the defendant, Deshaun Stafford, guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, defendant Deshaun Stafford caused the death of Ethan David Liming as the proximate result of committing or attempting to commit assault. Also, in count 3, the defendant Tyler Stafford is charged with involuntary manslaughter. Before you can find the defendant Tyler Stafford guilty of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Tyler Stafford caused the death of Ethan David Liming as the proximate result of committing or attempting to commit assault. And caused has already been defined. Before you can find the defendant Sean Stafford was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant Deshaun Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Also, before you can find the defendant Tyler Stafford was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant Tyler Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Again, those terms caused and knowingly have already been defined. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or its duration. As an alternative, the state has also presented the theory that the defendant, Tyler Stafford, acted in complicity with the principal offender, Deshaun Stafford, in the commission of the offense of involuntary manslaughter based upon the underlying offense of assault. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act constituting the offense or was not present when the offense was committed. Before you can find the defendant Tyler Stafford guilty of complicity in the commission of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant knowingly solicited another to commit the offense of involuntary manslaughter or aided and abetted another in committing the offense of involuntary manslaughter. Knowingly has been defined for you. A few more terms. Solicit. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, or to bring pressure to bear. Procured means to get, obtain, induce, bring about, motivate, or motivate. Before you can find the defendant Tyler Stafford guilty of complicity by aiding and abetting, you must find beyond a reasonable doubt that the defendant Tyler Stafford supported, assisted, encouraged, cooperated with, advised, or incited the principal offender, Deshaun Stafford, in the commission of the offense, and that the defendant Tyler Stafford shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including but not limited to the presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant Tyler Stafford at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abetter. The principal offense of involuntary manslaughter based upon the underlying offense of assault has already been defined. The defendant Tyler Stafford cannot be found guilty unless the principal offense was actually committed. When considering this count 3 involuntary manslaughter, you must determine whether the state proved beyond a reasonable doubt that the defendant Deshaun Stafford did not act in self-defense or defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant, Tyler Stafford, did not act in self-defense or defense of another when considering count 3 involuntary manslaughter. All of those terms relating to self-defense and deadly force and non-deadly force have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford acted in self-defense, you must find the defendant Deshaun Stafford guilty of count 3, involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant Tyler Stafford guilty of count 3, involuntary manslaughter. Next, in count 4, the defendant Deshaun Stafford is charged with assault. Before you can find the defendant Deshaun Stafford guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Deshaun Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Also in count 4, the defendant Tyler Stafford is charged with assault. Before you can find the defendant Tyler Stafford guilty of assault, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Tyler Stafford knowingly caused or attempted to cause physical harm to Ethan David Liming. Those relevant terms, knowingly caused and physical harm, have already been defined for you. When considering count 4 assault, you must also determine whether the state proved beyond a reasonable doubt that the defendant Deshaun Stafford did not act in self-defense or in defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant Tyler Stafford did not act in self-defense or defense of another when considering count 4 assault. All of those terms and concepts related to self-defense have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford acted in self-defense, you must find the defendant Deshaun Stafford guilty of count 4 assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant Tyler Stafford guilty of count 4 assault. Counsel, can you approach, please?
Judge wants a quick word with both the defense and the prosecution to make sure that they have read all of the instructions. This is very mundane, but it has to be done. The jury needs to know what they're deciding and the particulars of each count. In order to be found guilty of involuntary manslaughter, you have to first have been found guilty of assault. So if you find him not guilty of assault, then you can't have guilty of manslaughter. You see both Deshaun and Tyler. Tyler there with his hands on his head. This is their future at stake here. And from the judge's instructions, we will have a brief recess, maybe not as long of a lunch as they've taken in the past. In the past, it's been about an hour and 20 minutes. And when they come back from lunch, they would then start with closing arguments. I wouldn't anticipate closing arguments to take too long for each side, maybe 20, 30 minutes. You're not going to present the entire case all over again. So just the final things you want the jury to remember. And if you're the defense attorneys for Deshaun and Tyler, you want the jury to head into that jury room with as much confusion as possible, as much doubt in their mind as possible. And you are going to play up who was it? Was it Donovan Jones or was it Deshaun that went and confronted Ethan Liming? And there was an instruction in several of the instructions given the phrase initial aggressor. And I'm looking forward to having our Tara Coleman join us when we take this lunch break, because we will discuss who, if you are the jury, and this may be mixed, this may be part of the problem that the prosecution is going to have, who should be given the label initial aggressor. You will have some people that say that, oh, absolutely, when Ethan Liming and his buddies decided to show up to the I Promise school and use their splatter guns to scare, or if they were able to hit the three young men who were on the basketball court. We never determined officially if anybody on the basketball court actually got hit with those first splatterball guns, but we know it was Tyler who yelled out, "It's not a real gun." And that's when Donovan claims in his interrogation video that he went to then confront Ethan Liming at the car. And Deshaun himself thought it was Ethan Liming that ran up and shot with the splatterball guns into the basketball court. We know that's not the case. It was Ephraim and Mackay, his two buddies, that went up there to shoot the splatterball guns. But so was that the aggressor? The initial aggressor, does it go all the way back to the splatterball guns, or do you look at this idea of self-defense? Was there reasonable harm or imminent death coming towards you when Deshaun decides to go confront the car full of teens? It's your guess at home. It's your decision. Put yourself in the shoes of the jury. Who was the initial aggressor? Again, you're going to have two sides. I'm guaranteeing everybody watching right now says that Ethan Liming and his buddies were the initial aggressor when they showed up with their splatterball guns. You're going to have the other side, the other half of the people potentially watching, who say no. As soon as the firing was over, the blaster guns was over, Deshaun went and confronted Ethan Liming. He's the initial aggressor.
I'm going to go back to count 3 and reread to you kind of my conclusory paragraphs related to count 3. I did misspeak. There were a few incorrect words. They will be changed and corrected in the physical copy that you will receive, okay? But when we were talking about count 3, involuntary manslaughter, If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford did not act in self-defense, you must find the defendant Deshaun Stafford guilty of count 3, involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant Tyler Stafford guilty of count 3, involuntary manslaughter. And then we discussed the beginnings of the count 4 assault, which requires that the state prove beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Deshaun Stafford in the first instance and the defendant Tyler Stafford in the second knowingly caused or attempted to cause physical harm to Ethan David Liming. Self-defense, we talked about, does also potentially apply to this count, and you must consider those concepts and definitions as they have already been given to you. As to count 4 assault, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshaun Stafford acted in self-defense or in defense of another, you must find the defendant Deshaun Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshaun Stafford, and you find that the state proved beyond a reasonable doubt that Deshaun Stafford did not act in self-defense, you must find the defendant Deshaun Stafford guilty of count 4 assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant Tyler Stafford guilty as to count 4 assault. Testimony has also been admitted indicating that the defendants fled the scene. You are instructed that defendants' actions in fleeing alone do not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find that the facts do not support that the defendants fled the scene, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendants engaged in such conduct, and if you decide that the defendant was motivated by a consciousness of guilt, you may, but are not required, to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give to this evidence. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdicts as to any other count. The defendants may be found guilty or not guilty of any one or all of the offenses charged. You must also separately decide the question of guilty or not guilty relative to each of the two defendants. If you cannot agree upon a verdict as to both the defendants, but do agree as to one, you must render a verdict as to the one upon whose guilt or innocence you do agree. You must separately consider the evidence applicable to each defendant as though he were being separately tried, and you must state your findings as to each defendant uninfluenced by your verdict as to the other defendant. Counsel, are there any other additions or corrections to the jury instructions so far?
I would renew my objection.
Yeah, that objection will be renewed. And then at this time, ladies and gentlemen, as we discussed, I will take a somewhat shorter lunch break. Why don't we reconvene? Okay.
Again, the defense wanting a few more words with the judge about the instructions that were given. They are trying to be very particular. If your client's future is on the line, you want to make sure that...
All right, so let's take about a 45-minute break for lunch. Let's reconvene about 1 o'clock. At that time, we will continue with the closing arguments of counsel, and then I will finish the instructions related to how you should conduct your deliberations. We still have, obviously, some things to present in these proceedings. You are not to begin discussing amongst yourselves the case at all until we have finally concluded. And once again, do not discuss the matter with anyone else. And I will see you after lunch.
Dan DeRose with 19 News as we get a look at Deshaun, and I believe some of the jury members are going to walk through here, so we're going to jump off of that picture until the jury is out of the room. A little bit of a surprise this morning, and we're going to go through all of it. We're not going to leave our gavel-to-gavel coverage. We will get our legal analyst, Tara Coleman, to join us here shortly to discuss the really, really big surprise move. And I believe the jury is out of the room now. We can see Deshaun there and his brother Tyler, knowing that the end of this trial is in sight and that their futures will be in the hands of that jury. The surprise move was that the defense decided to call no witnesses to the stand, and that is their right. We'll talk with Tara Coleman when she joins us about who potentially they could have called, whether they could have called character witnesses, whether they could have called family members, experts, to talk about that. As we move to the shot of our clock, that tells us that we are going to be, and I see Tara jumping in just right now, so we will have her join our conversation here about the surprise move of the day, that we get no witnesses whatsoever, no experts, no family members joining us or testifying for the jury. Going to welcome in now Tara Coleman. She's our legal analyst. She's been helping us all through the trial. She has witnessed probably just as much of this trial, if not all of it, throughout the whole way to make sure she's informed on it. Tara, how are you today?
Wild. This is wild, right? Yeah.
A little bit of a surprise move.
Yeah, a bit of a surprise move there. But as I was saying yesterday, it was hard to think who the defense could call today. And I think the reason we didn't see any witnesses called today is because I'm not so sure the defense realized how this was going to go. And I think, given the inconsistency in the testimony that is creating what I am calling the Donovan Deshaun confusion, I think the defense made a game time decision to double down on that and go that approach of, there's not beyond a reasonable doubt, if Deshaun was the first to approach the car, or if Deshaun is the one to have given that fatal blow to knock Ethan Liming to the ground. And
Even
so
though
because of that, yeah, I think they just went with it.
even though he says it in the interrogation video. I mean, that's the biggest piece of evidence that the prosecution has, is Deshaun, in his own words, 9 days after the fact, saying, I punched him, he went right to sleep.
But Dan, look at all the doubt around it. He lies at first in that interview clearly to protect Donovan Jones and Tyler Stafford's girlfriend. And you saw the defense hit on that a little bit in their questioning. I think he got objected to, but basically said, he's clearly covering for Donovan. And the fact that it came out in this trial that Donovan Jones had way more involvement than what was first brought out almost gives reason to make you doubt that video of Deshaun Stafford admitting to being the first to approach the car.
Why did we not hear from Donovan Jones? We speculated a couple of days ago, wouldn't he be an interesting witness for the prosecution? He gets this deal where he gets a suspended sentence. He's not charged with involuntary manslaughter, even though the three individuals, the three friends of Ethan, say, yeah, at one point it was 3-on-1, meaning it was Donovan, it was Deshaun, and it was Tyler, all going after Ethan Liming. Why do we not hear from Deshaun?
It depends on what he would have said, right? And we just don't know. The prosecution would not want to call him if he would get up there and say, I was the first to approach the car, I knocked him out. You would think the defense would want to call him in that instance, but maybe the defense isn't entirely sure what the statement is. That to me is a big kind of hole there, because depending on what his statement would have been, it does seem as if one side or the other could have benefited from calling him. So I'm just not sure there.
You take the chance if you're the prosecution. We know he's the cousin of Deshaun and Tyler. What is he going to say on the stand? He obviously is read his rights. He needs to tell the truth. But it is a wild card, and that maybe is why the prosecution doesn't call him.
Yeah, and he could be maybe not a great witness, right? And you don't know, is he going to be someone that's going to present on the stand to the jury? Was he the troublemaker in all this and the one most involved, even if he's going to say the opposite, so it really just depends on the type of witness and what they are going to say. And it clearly both sides did not see it in their interest to call him. So I don't think we'll know on that one without having inside baseball.
Yeah, big piece hanging out there. Let's talk about the last person who was there, the last witness to this. There were 4 people in the group of Deshaun and Tyler and Donovan Jones, Tyler's girlfriend. And I thought this was a really interesting moment in court yesterday. I'd never quite seen anything like this. They started asking about Tyler's girlfriend, and they asked the lead detective, did you ever reach out to her? And he said, we tried to, that she lived in the Cleveland area, he thought, and that when they noticed that at the start of the trial, they apparently didn't bother coming up here to talk to her. But when they saw her show up for the trial, the detective said to her, we would love to talk to you if you have anything to say. If you have anything to shed light on, we would love to hear from you. And she decided that she didn't want to talk. And in fact, they go as far, the prosecution said, "Do you see that woman in court today?" And the detective said, "Yes, she's sitting right there in the sweater." So here you have the last person who witnessed this. They only interviewed 6 people in connection with this. They interviewed Ethan Liming's 3 friends, and then they interviewed Deshaun, Tyler, and Donovan Jones. She was the last missing piece. What do you make of the fact that they pointed her out in court? They made it a point to say, "Is she here today? Can you point to her?" And he said, "Yeah, she's right over there in the sweater." What does that do?
And that was the prosecution that pointed her out, or the defense?
It was the prosecution. When the prosecution had the lead detective on the stand, they were asking about everybody he interviewed. They asked about Tyler's girlfriend. He indicated that she did not want to talk. She had nothing to say to them. And he asked, "Is she here?" And he said, "Yes, she's right over there in the sweater." What does that do?
I see that just getting out of the way. You're doing it first so that the defense cannot use her as a sticking point to say they did not do a thorough enough investigation. So you're getting it out that she wasn't comfortable talking to police. She didn't want to talk to us. And they clearly didn't feel it was necessary to subpoena her and force her to testify. So the prosecution most likely did that so that it's out of the way and the defense can't then come up and use that as a point of not doing a thorough investigation, because we did see the defense do that with the cell phone collection and text message review, which is just such a standard and common thing you would do in an investigation that was not done here. So that could have been just another point to say, you got Deshaun Stafford to say it was him and you just stopped there. You just took his word for it and you did not want to get to the truth.
And Tara, we're going to play that. It's just a 4-minute clip here. We've got another half an hour to go here, so we're not going to miss anything. This interesting, and you just sort of scratched on the surface. I was baffled by this conversation about cell phones. We know in this day and age, cell phones, whether they're cracked or supposedly dead, they're not ever completely dead. There's always information that can be taken from a cell phone that looks like it's broken. You're about to see the defense question the lead detective, how many cell phones they looked through, they investigated, and what kind of information did they get. Take a look.
So knowing that things change and people change, there are things we could have done to try and see whether, we have scientific things we could have done, right?
Yes.
Like you had the phones from all the boys in the car, and that could have told us what happened leading up to this incident, right?
It's possible.
But according to Detective Mike Williams, he didn't see a need for it, you didn't see a need for it, which would have been simple as turning them on and seeing if you could read the last day text messages, right?
No, it would not be as simple to do that, no.
We all have cell phones. We've all lost data. You have a whole crime lab up there on the second floor and they've got a machine that deals with phones, right?
That's correct.
In this case, no one even bothered to turn these things on to see if you could read them through the glass, the broken glass.
We did attempt to turn them on, but they were broken and they would not turn on.
And there's a next step you could have followed that we just chose not to. We didn't send it out to get looked at. We didn't send it to the crime lab. We just turned it back off.
We sent it to the crime lab for DNA processing.
Well, let's talk about DNA. Well, let's stick on phones for a minute. Ethan's phone's missing, right?
Yes.
That seems odd.
Yes.
It's an iPhone, right?
That I don't know.
Okay. Well, iPhone, Android. When you contact the phone company, you talk to the parents and said, find my iPhone, find my Android. Where did it pop up at?
I did not do that. I believe Detective Mike Williams might have.
We didn't hear about that, right? I mean, that's a mystery where the phone went.
Yes.
We don't even know whether or not someone's still using that phone today. I mean, the phone company would have records, but somebody would have to go get them. And no one did that, right?
No.
And likewise, maybe even more importantly, these boys on the basketball court had 9 days forth to each other. We can assume. They're all relatives, right?
Yes.
They all are reading the paper and watching the press conferences, and you can assume, you can guess they're probably talking about getting their story straight.
It's possible. I don't know.
You took each one of their cell phones into custody when you arrested them, did you not?
I don't recall. I'm not sure.
That would be pretty easy to do. You arrest them, you take them, you ask for their cell phone, and then you turn the cell phone on, you look back and you go, that's where you guys got your, that's where you did that. But we didn't even turn on the suspects' phones to see what kind of things they were saying before the incident, after the incident. That'd be good to know, wouldn't it? Especially now with Donovan's different involvement.
Yeah, through the course of our investigation, through our 6 interviews, I did not see the need to have the phones due to the cooperation of everyone.
I guess what I'm saying is we don't know these people, these kids, these other people.
I would object, that's not a question.
We got to take this 19-year-old out of his statement, and that's what we're doing.
Object.
Yeah. Sustained.
You know damn well that Deshaun was covering for Donovan that night when he said, a random person. Right?
I have no idea. I
He knows who
don't know
Donovan
his
is.
character.
He knows who Donovan is.
I would object.
Sustained.
You know he knows who Donovan is, right? They're cousins.
Correct.
So he kept Donovan out of it, covered for him.
Correct.
How do we know he's still not covering for him?
I wouldn't know.
Based on what these boys said about Donovan's involvement, based on Donovan no longer being part of this, wouldn't it be good to at least have looked at the cell phones or asked somebody? We just took that interview, case closed. No further investigation. Is that what happened?
There was more than just that in our investigation. There was a lot of evidence and a lot of different other things as well.
You just heard some really good cross-examination by the defense. Again, put yourself in the shoes of the jurors. The defense has to send you to that jury room with enough doubt that maybe they just didn't do a good enough job here. We've got Tara Coleman, noted defense attorney here. She's our legal analyst for this case. Tara, that was some kind of cross-examination. We all know the power that cell phones have, and they didn't look into anybody's cell phone, let alone find Ethan's phone. Let's start with, you didn't look through Deshaun's phone. You didn't look through his brother's phone. You didn't look through the cousin's phone to try and find text messages that say, hey, man, this is what you're going to say. And if they ask you this, you're going to say this. And I can't believe this. I can't believe the punch I threw killed that kid. There had to have been a conversation between those 3 individuals.
That's huge. And even if there aren't texts, even the phone records, is there heightened back and forth during that time. And remember, this defense attorney is a former prosecutor. So he knows the capabilities. He knows how commonplace it is to image cell phones. And it does not matter if those cell phones were cracked. They didn't take images. And that's just very commonplace. We even do that in civil cases, right? Let alone where you have people's livelihood and life on the line, right? To be possibly put away to prison. Of course you do that thorough investigation. I thought that was very, very to their advantage to point that out. And it's beyond me why that didn't occur. And what it is probably leading the jury to believe is once they heard Deshaun Stafford's interview, they kind of just wrapped up their investigation and went with that narrative. And the big issue there is, as the defense pointed out, it is clear Deshaun Stafford may be covering for Donovan Jones.
Because, and we know that because in the beginning of that interrogation video, he says there were 3 of you on the basketball court. Who was there? And he says, it was me, it was my brother. And they said, okay, who's the 3rd guy? And he said, some random guy. claimed he didn't know him. Well, at that point when they're interrogated, they know who it was. They knew that it was Donovan Jones. Donovan Jones had already been arrested. He was arrested the same time that Deshaun was picked up and that his brother was picked up. So they knew they were lying. He was lying there. They go on to say there was a fourth person on the court who was the woman that was on the basketball court. He says, we didn't know her either. Well, he's lying there too because we know that was the girlfriend of his brother. So
yep,
you
and
send,
if I'm on the jury, I'm like, isn't that a lead you might want to follow up on? Does that kind of cause some doubt into how that interrogation went? Especially you have him in there. He didn't ask for an attorney. He, was read his Miranda rights and wanted to get that story out. So it is, it does lead you to believe or think that could be a possibility that he was covering.
And let's say this, in that interrogation video, we do see at the very beginning, they do read his Miranda rights. In fact, the detective says, he doesn't read through the whole thing. He says, you have the right to remain silent. Do you understand that? And he says, yes. You have the right to have an attorney present when we question you. Do you understand that? He said, yes. He read the whole thing to make sure that he wasn't confused by the whole paragraph. He read it line by line, and he still spoke. Tara, as a defense attorney, should you ever talk in that situation, seeing as how that's the big key piece of evidence that the prosecution has right now? Really, the really big smoking gun here is him saying, yeah, I walked up, I punched him, and he went right to sleep. Should you ever answer questions from a detective without an attorney?
No, don't.
You're just going to leave it right there and just say, don't. You can see where in this case it got Deshaun where he is. Because if you have the other three take the stand and say, well, I think it was Donovan, one says, I think it was Deshaun, there you have a lot of doubt to send the jury. Think about how much doubt the jury has going in without the video of Deshaun in the interrogation room.
Right. Exactly. And what's great here for the defense is even with that interrogation, there's even some doubt there. So again, that's truly, I do believe that's why they rested today, just because of how this has played out.
Let's talk about, and we discussed this during yesterday's break, what happens in every trial when you have the prosecution, you have the defense. When the prosecution goes first and they get done with their case, there's always this point in the middle where the defense comes to the judge and says, look, Judge, I don't think the prosecution did their job. I don't think they proved beyond a reasonable doubt, so I want you to throw this whole thing out. Let's stop right now, throw it all the way out. We're about to play you the clip of the defense asking for this to be thrown out. I want you to be very clear if you're watching. I want to be very clear. The jury is not in the room for this. That is a major point. This is a conversation between the prosecution, the defense, and the judge. The jury is not in the room for what you're about to hear. This played out this morning when the defense, before they were about to present their case, they have the ability to ask the judge to throw the whole thing out. Take a listen. This is 7 minutes. They lay the groundwork, and then the prosecution gets to come back and say, well, this is why we think we did do our job. And then you get to hear the judge's response. Take a listen.
At this time, on behalf of Defendant Deshaun Stafford, I will move for a directed verdict of judgment of acquittal on all charges. I recognize that it's unusual, to say the least, for a court to take this decision away from a jury when we are this close. It would be that unusual, exceptional case. This might be that circumstance. This might be that circumstance, especially as it relates to count one, the involuntary manslaughter by way of aggravated assault. We've got some real issues. The state has some real issues with causation. In order to find my client guilty, a jury would have to find beyond a reasonable doubt that he caused the death of Ethan Lyman. When we started out here, maybe that was just assumed, but that is no longer a safe assumption. There's been ample evidence that somebody else was involved in this, namely Donovan Jones, that Donovan Jones may have been the aggressor, at least as it relates to the boys involved in their response to Ethan and his friends. And when it comes to causation and when it comes to serious physical harm and the deadly force required, none of that's been proven. All the assumptions we had early on kind of fell apart with the state's case. At this time, Your Honor, I'm asking this court to take this least portions of this case, specifically the felony 1 aggravated assault and the felony 1 involuntary manslaughter by way of aggravated assault, the felony 3 involuntary manslaughter by way of assault, and I'm asking you to direct those out. There's not sufficient evidence to send those to a jury. At most, what you send to the jury is what Donovan walked away with, which is the misdemeanor assault charge. Thank you.
Mr. Gallagher.
Then I too would make a criminal rule 29 motion for a judgment of acquittal. It's a two-part motion. The broader concept is under the new law, the prosecution is required to show that there was any act that Tyler Stafford made was not self-defense. I don't feel that they've done that. If he was acting in self-defense, they haven't proven otherwise. That's the broader part of the motion. There's a more specific, tailored second part to the criminal rule 29 motion, and it goes to the third-degree felony involuntary manslaughter. Specifically, looking at the indictment and also looking at the bill of particulars that we were able to obtain. It's a rather lengthy bill of particulars, but I would say what we used to call the two-wit would be in paragraph 7 and 8. And in paragraph 7 and 8, they're talking about Deshaun Stafford, Tyler Stafford, and then in paragraph 6, Donovan Jones engaged in a fist fight with Ethan Lyman. Paragraph 8 says that Ethan fell backwards from the blow, hitting the back of his head on the pavement. He was knocked unconscious and died from his head injury. So the person who caused his head injury is the person who is potentially responsible for involuntary manslaughter if it's not a self-defense act. We heard from the medical examiner that the injury to the back of the head was the cause of death. Everything else, although horrible, is not relevant to the charge of involuntary manslaughter. There's been no testimony that Tyler Stafford did anything to cause Ethan to fall backwards, to hit his head. There's no testimony that Tyler Stafford slammed into the ground. We heard testimony from one witness that Deshaun Stafford hit him and knocked him backwards. We heard testimony from two others saying they think it might have been Donovan Jones. We heard no testimony of any time that Tyler Stafford did anything to cause the death of Ethan Lyman. And going on what our notice comes from the indictment and from the bill of particulars, specifically paragraph 7 and 8, that was not proven. There was no testimony to this. The only thing we had was from Detective Hornacek at the end. He said, well, there was a statement, all three jumped him. Like all three are responsible for the manslaughter. Well, that's not in the indictment. That's not in the bill of particulars. So we're relying on this bill of particulars to tell us what the legal theory is, what the allegations are, how to defend ourselves from the facts of the law. There was no testimony backing up this bill of particulars. So you're making a broader Rule 29 motion on self-defense for both of Tyler's charges, but very specifically to the third-degree felony involuntary manslaughter. Causation and proximate cause, they're just not there.
Your Honor, and I'm sorry, I want to adopt Attorney Gallick's, the argument he made for Tyler. I want to adopt that from Deshaun. I never got past cause and whether or not Deshaun even caused this in my argument. But really, for the state to prevail, they've got to prove, there had to be evidence that Deshaun did not act in self-defense. There had to be some evidence of that. They got to prove that to this jury. We never got that far. There's been no evidence that would establish that Deshaun was not acting in self-defense. We heard from no one that said anything contrary to that. There's no way that a jury can find that Deshaun didn't act in self-defense because no evidence was presented to that. And that's the effect of the new law, and that's the burden shifting. So I just said in my opening argument here, Attorney Gallick brought it up for Tyler, and I bring it up for Deshaun. I think that's how it's going. Thank you.
On behalf of the state.
Thank you very much, Your Honor. Just very briefly, may it please support. Your Honor, the state does believe that we have met our burden in terms of presenting our case to the jury for their consideration. Regarding Deshaun Stafford, he does have the involuntary manslaughter by way of aggravated assault. The state does believe that the evidence presented is enough for the factual determination to be made by the jury regarding causing serious physical harm to the deceased, Ethan Liming, and that his death did occur and was caused by that aggravated assault. Additionally, the state does believe that we have met our burden regarding the essentially the lesser count of involuntary manslaughter by way of misdemeanor assault in the event that the jury were to find that facts would play out that Deshaun did not cause serious physical harm and just find that he did assault Ethan Liming. The evidence was quite clear, Your Honor, that this was not a situation of self-defense, that this was in fact a brutal attack, initially by Deshaun, an older young man, and then ultimately with his brother and cousin joining in, ultimately creating a 3-on-1 fight situation. That did cause the death of Ethan Liming, Your Honor. Additionally, we did prove that that was on June 2nd of last year here in Summit County, Ohio. Additionally, Your Honor, regarding Tyler Stafford, the state has met its burden there as well regarding the involuntary manslaughter by way of assault. Evidence presented by several witnesses and statements of the defendants themselves indicated that they were actively engaged in a fight with Ethan. Really, to call it a fight, Your Honor, is insulting. It was not a fight. It was just an attack.
Strong words there by the prosecution in the attempt by the defense to implement Rule 29. That's essentially saying, Judge, we want you to throw this whole thing out because we don't think they met their burden of proof. The judge ultimately disagreed with the defense and will proceed, obviously, to let the jury make the ultimate decision. Tara, that was not a surprise. We know this happens, and 99.999% of the time, the judge doesn't agree and lets it go to the jury.
That's right, Dan. I would agree with that. It's such a high bar to get a directed verdict. Well, we call it directed verdict in civil cases. Here, a motion for judgment acquittal. And it's just such a high bar, but you have to do it. I will say, in this instance, if there was a strong motion, Rule 29 motion, this was one of them. I will say that.
Yeah.
Even
so
though
you're
it's
telling me there's a
surprise-
chance kind of situation.
Yeah, but it's no surprise that this was not granted because, giving the case over to the jury is such a core tenet to our justice system that it's very rare where we take that opportunity away from a jury. So it's not surprising, but I will say of the Rule 29 motions you'll see, this is one of the strongest ones you'll ever see.
Yeah, talking about the confusion. We're not going to play for you the jury instructions because we want you to stay awake. You may have had lunch and you don't want to be put to sleep right now. But there are a couple of terms, Tara, that I want you as a defense attorney to help us understand. This phrase, initial aggressor, when it comes to the assault charges and the involuntary manslaughter charge. And from my position sitting through this entire trial, I'm not going to take a position, but from what I see, you could make the argument, and there could be this argument in the jury room, that there's going to be a disagreement on what it means to be the initial aggressor in this case. As I said earlier, you're going to have half the people or some percent of the people who say, well, it was Ethan and the 3 young men who show up with the splatterball guns. They initiated this whole thing. They're responsible. They started it. You're going to have some people on the other side of that coin that say, well, wait a second. That's not the initial aggressor. Once they shot those paint pellets or the splatterball pellets, they went back to the car. You're going to have some people who say Deshaun was the aggressor when he came over to the car and wanted to confront Ethan. You can say that, oh, this was basically over. If they would have stayed on the basketball court, if they were worried about their safety and self-defense, they could have said, and I'm surprised we didn't hear this from anybody. Why didn't they just stay? And maybe we will hear this in closing. If they were so worried about their safety and self-defense, why not stay on the basketball court? But then you have Deshaun, who comes over to the car, confronts Ethan. We know Ethan does shoot him again at close range. And so there may be the instance for initial aggressor. But that's going to be tough for the jury to decide on exactly who is the initial aggressor.
It is. That's going to be very tough for them. And I noticed that there was not necessarily an instruction to guide the jury as to what point in time they should be considering when it comes to who is the initial aggressor. So everything you just laid out there is most certainly going to be a conversation that's going to play out in that jury deliberation room. But you have to remember, before you even get to the self-defense question, you have that causation question, right? And it's, did the act of Deshaun Watson, is that what led to and caused the death? And if that's the case, you have to ask, okay, well, was that act in self-defense? So if you think of it that way, you would tend to analyze the initial aggressor after the actual fight starts. But again, they were not directly instructed on that. So that could be something we see cleared up a bit in closing arguments, or they'll kind of just leave that up for the jury to decide. But everything you laid out is certainly going to be discussed in that deliberation room.
I think you've got a little football on the brain. It's something I've had to try and, you said Deshaun Watson. We're, of course, talking about Deshaun Stafford. Don't worry about it. It is... it is.
I apologize.
No. It has been obviously we're dealing with Deshaun here and Deshaun Stafford. It is an easy mistake to make, but I can definitely see. I'm sure, and I'm going to be honest, I haven't been watching our Facebook comments. We've been obviously streaming gavel to gavel coverage here. I bet there is sort of an argument happening on social media during the coverage as to who should be considered the initial aggressor. You can absolutely see the side of the people who say, oh, clearly a car full of 4 young men with splatter balls showing up to shoot towards 3 young men who were just playing basketball. They are the initial aggressor. But then again, you can see on the other side of that coin, no, the shooting was done. They went back to the car. This whole thing should have been over. It was Deshaun running up to the car to confront them. Now, is he the initial aggressor? And then you have the third one. Well, no, wait. Ethan Liming is then given the splatter gun, and he shoots Deshaun at close range. Isn't he the initial aggressor? Going to be something that can tie up a jury in this? How big of a sticking point is that for the jury?
I think that's a big sticking point. And I just want to point out, Dan, that's why coverage like this is so important, because this very discussion we had, so I'm home and having birthday dinner with my family, and we were actually discussing this, and a lot of views came out. Well, it's so unfortunate, but they went with these splatterball guns and set all this emotion. And if you don't hear all of the facts that come out, how we've heard this play by play, it really doesn't give you the context to consider all of this. And so the jury is going to be the most knowledgeable people at this point to have that discussion in that deliberation room. And it just points out to me how important this coverage is, because just from the outside, just knowing the basic facts, everything you laid out is going to be the argument, but you need to have the context around it all to sift through it.
And we haven't even touched the stomping, the kicking, and you got that from the defense, and you even heard that from Attorney Gallick when he tried to get the entire case to try and get an acquittal for his client, Tyler. He said, look, all the extra stuff was unfortunate, but it wasn't what caused his death. What caused his death was when he fell back, hit his head, the brain injury, it jarred his brain. That's what caused the death. We haven't even discussed the whole how that weighs with a jury, and I'm going to ask you that. That's not what caused his death, but the fact that it was 1-on-3 at some point, whatever point you think when Ethan went back and hit his head, and I've thought about that too. Of course, Deshaun is going to say in his interrogation video that he went to square off with my brother. My brother called out my name, so I went and hit him. That's when he went right to sleep. Well, then where does Deshaun come in? Again, he was protecting Deshaun like he didn't even know him. So you have 3 witnesses who get on the stand who say at one point it was, in fact, 3-on-1. It was stomping, it was kicking. In the words of one of the witnesses, it was ground and pound once Ethan was on the ground. Where will that weigh with the jury, or does the jury need to, and I'm not saying it's not a factor, it is unfortunate, it is terrible if that happened, but does the jury need to put that out of their mind?
So where that's going to play in is when the jury has to determine whether or not the state has proved beyond a reasonable doubt that the defendants did not act in self-defense or in defense of another. And when you have these kind of what we'll call, I guess, extracurricular actions, right? That tends to undercut that they were acting in self-defense. If you go through each of those 4 elements, if you have revenge on if it looks like a revenge type action, it's going to undercut if they were really acting in self-defense. So I think that's where it's going to play in the jury's mind. If I'm the defense in closing arguments, I'm hitting home. Here, you consider up to this point.
And
that's
I'm,
what matters.
and I'm not about to demean anything, but if you're truly in this idea of I was worried for my brother, I was worried for myself, that's why I punched him, he was going after my brother, I think we can all agree, okay, on the surface that looks like self-defense. Then he makes the comment that he went to sleep, and so that means he's knocked out. Well, the threat is ostensibly over at that point. I can't be threatened anymore by somebody who's knocked out. The detective then asked him, what'd you do after that? He said, I hit him twice. He said, after he was knocked out, you hit him 2 more times? And he said, yes, I hit him 2 more times. So again, this is going to be tough for the defense to get away from or to clarify this explanation of self-defense.
Right.
As a defense attorney, what do you, let's say you are the defense attorney for Sean Stafford, how do you craft this message? What needs to be in your final message to the jury before they head into that room?
You're going to have to break down very clearly causation and the importance of causation here.
Explain
Because
causation. I know that's...
Yeah, you don't even get the underlying charge, right, without that. And so here, and let's go to the jury instructions, right, how they were instructed. Okay, so you're going to have to show that Deshaun Stafford caused the death of Ethan Liming as a proximate result of committing assault. Okay, now the cause action is going to be whatever action you set in play. The assault has to be a natural and continuous sequence that directly results in the death. That means this is all going to come down to who threw the punch to knock Ethan to the ground. Now, because we have the medical examiner saying the cause of death was when Ethan Liming hit the concrete, okay? Everything that happens after that point, you just hit home, no causation there. Anything that happened after Ethan hit the ground did not cause his death. Okay, so those actions are not what lead you to finding either Deshaun Stafford or Tyler Stafford guilty of involuntary manslaughter. And I think that's how it's causation, and you just have to explain that clearly to where after the point of death, that's what my client is charged with up to that point. There are no, the charges aren't based on the actions that occurred after that.
Now let's get to the prosecution's side of things. And if you're just joining our coverage, I'm watching the courtroom while the judge said we'd be back around 1 o'clock. We've been a little late before, but this was going to be a shortened lunch. When we come back from lunch, it will be closing arguments. Both the prosecution, the defense will be given time to go right up to the jury. This is generally when we see some of our most dramatic moments in court. I suspect we will see the gun come out again. I suspect when the defense goes to make their argument, he will rattle off that splatter gun and say, my client thought he was being shot at. That creates this level of fear. That creates this level of I need to protect myself, and that leads into defense, so self-defense. So now let's flip the coin. Let's go into the prosecution side of things. What does the prosecution need to hammer home to get a guilty verdict before that, or to get a guilty verdict as that jury heads into the room?
Yeah, so I'm not as good at this side, but if I'm the prosecution, I think you are going to be highlighting all of the actions that took place along the way that will lead one to believe that this was not self-defense, that these were revenge actions, right? So all the extra, what we call the extracurricular actions, you're going to hit on that. You're going to hit on the fact that the prank was over. Why come back to the car? So anything you can plant in the jury's mind to undermine that they truly acted in self-defense is that what they're going to have to hit home as the prosecution.
We're looking live inside the courtroom. We have seen Tyler Stafford make his way. Now here's his brother, Deshaun Stafford, making in his way. Before we let Tara go, Tara, explain to our viewers how important the next, let's say, closing arguments, and maybe you can help us there. You don't want to belabor the point here. If you're either side, if you're the defense or the prosecution, you don't want to take an hour. You don't want to make this seem like you're grandstanding. How long do closing arguments take, and how important are they?
Yeah, so judges usually have standing orders on how long you get, or it will be decided ahead of time how long each side gets. But you're right, you do not want to bore the jury here. And it's hard to be boring in closing arguments because they're so crucial, but you just want to be spot on and get into their minds what they need to be thinking about. But I will say, in my opinion, closing arguments, this is where the game is lost or won. I mean, this is so important because this is, you're going to lay the context in how the jury should be thinking about all of the evidence they've seen across what we're on day 4, these 4 days. So highly important, but you're right, Dan, you want to be as succinct as possible and as powerful as possible in your closing arguments.
No stuttering, no stammering. I think it was this, or you remember we kind of had that day.
And not rehashing a lot of things. You're not going to rehash a lot. You're going to highlight the key basics that you want to make sure they remember.
And then let's talk about, because I don't know that we'll see you again until we get a verdict. Let's talk about the jury in a case like this. Let's assume, and we're just going to make a little bit of an assumption. Again, we're looking live in the courtroom. We're not missing anything. We're going to make sure you see every single second of this. Let's assume closing arguments are 10, 20 minutes maybe from each side. The judge will then have to give the final, here's what you're going to do. You're going to go back and elect a jury 4-person. Then you're going to start a conversation, and she'll give those final instructions. So let's say the jury has this case by 2 or 2:30. Any predictions for how long a jury could deliberate in a case like this?
If we end by 2 o'clock, I'm not so certain we'll get wrapped up today, because